Okay. All right, guys. Hello, everyone. Thank you so much for joining us. My name is Hannah Roth, and I work with Predictive ROI. I will be helping to moderate the Q&A today. So before Sharon begins, I want to walk through just a few housekeeping items. So here we go. Please put yourself on mute so we don't get background noise. As you guys can see, there's quite a few people on the call today, so we want the sound to be as clear as possible for everyone. Also, Megan just hit the record button, so thank you for that. The session will be recorded. If there are questions you would prefer to ask in private, feel free to email them to kayla@legalandcreative.com. And I will go ahead and put that into chat right now, so everyone has her email address for any questions they want to ask privately. The format for this Q&A is going to be about 20 minutes of fast-paced teaching. This session is a little special because you'll actually get to work through a hypothetical campaign and see what legal risks and opportunities are along the way. So after that, we will open up the floor for about 40 to 45 minutes so you can ask your questions. Feel free to ask questions along the way in chat. Sharon will answer as many questions as possible, but odds are good that we won't get through all of them. So for those questions that we don't get to today, our goal is to reach out via email. If you can, turn on your video unless you are engaged in another activity, you're eating lunch or something like that. It's more fun to talk with people than a black screen. So please, if you're able to, go ahead and turn on your videos. And finally, don't be intimidated or afraid of asking dumb questions. The whole purpose of the session is to learn. And if you have a question, odds are good that 10 other people in the room might have the same or similar question. Sharon got a law degree, so we don't have to, so ask questions. So that pretty much wraps up housekeeping. So now I'm going to go ahead and introduce Sharon. Most of you probably know her, but I'm sure there's a few that don't. So I have known Sharon for about 2 years now. And for those of you who also know Sharon, she is an absolute authority in her space. She is super generous with her knowledge and time, which makes her an amazing asset and a great person to know and to work alongside. For those of you meeting Sharon for the first time, she is an intellectual property and marketing law attorney. She specializes in helping marketing agencies all over the country protect, enforce, and monetize their creative assets. She is also a regular guest speaker for Agency Management Institute. She's the former president of the American Ad Federation of Cleveland, and she serves on the American Association of Advertising Agencies Legal Consultant Panel. Sharon regularly teaches and consults on topics of intellectual property protection, artificial intelligence, and everything that goes along with that rapidly evolving topic, marketing agency relationships, and the legal implications of social media. So today, as I mentioned before, she will be walking you through a hypothetical campaign from start to finish so you can identify and mitigate legal risks along the way and leverage opportunities that you may not know exist. So with that, I'm tired of hearing my own voice. So Sharon, go ahead.
Thank you, Hannah. Well, welcome everybody. I am super excited about today's time together with all of you because we spend a lot of time, and I know that agency professionals spend a lot of time. I'm going to get my screen set up here as I'm talking with you. We spend a lot of time talking about getting the client, getting the business, how to negotiate a contract successfully, how to make sure we're mitigating risks. But then what, right? You get started with the work and you are thinking about the creative process and how you're going to wow your clients and how you're going to make sure that you get buy-in from the clients about all your great ideas. And what about the legal risks that you encounter while you're thinking about all those things? It's sort of, we get a lot of panicked calls at the firm because you're so excited about winning the business and you're so excited about strategizing the business. Nobody, most of all me and the folks at my firm, nobody wants to see a great creative idea get squelched because of some unanticipated legal risks. So what we're going to talk today about is a typical day in the life of one of you or one of your team members as you think about how to concept and create and then execute a strategy, a campaign, some awesome piece of work. And my goal is to quickly go through some content here that's going to help you spot issues better the next time you plan a campaign or want to recommend a strategy to your clients. So we're going to talk through the lens of a model campaign that is a figment of Sharon's imagination. And it is integrated, multifaceted. And so there's lots of opportunities for lawyers to step in and ruin your fun. So let's talk about what the campaign, let's set the stage for a minute. Imagine you and your agency have been engaged by a new client that happens to be an insurance company, and they have decided that they need your help to reach a new generation of consumers who aren't typically buyers or willing or enthusiastic buyers of insurance products, right? Insurance is considered a little bit old, a little bit boring, something maybe your parents have to think about, but not you. So in order to try to get those folks thinking a little bit earlier about, planning for the future, risk, everything, um, we've concepted a campaign called Everyday Risks. And this is to get younger people, millennials, Gen Zs, thinking about insurance in a positive way and how it fits into sort of their wealth planning and their future. So here are the model elements of the campaign. We are going to develop some new taglines, everyday risks, ensure your better future. We're going to develop a new microsite where we can have lots of content, assets, and other engaging content. It's going to have original market focused content, video interviews, perhaps with consumers or experts. And maybe we'll be teaming with some influencers to create some of that content. Downloadable resources, contact page where folks can submit information to either get a quote, be paired with an advisor, whomever. We're also going to generate some excitement by doing a survey. And to get people to answer that survey, we're going to do a contest or sweepstakes. We really want to work heavily with influencers so that they can make insurance more compelling or sexy, if you will, for younger buying audiences. So we will talk with and interview influencers, perhaps in lifestyle spaces or who work with financial brands. The sky's the limit there. A monthly e-publication, which will have relevant content. And let's not forget that some of the content we think it'd be convenient to use AI to generate because we're going to be creating a lot of it. Some of it we'd like some starting points or inspiration. Some of it we'd like some help with first drafts that we're going to polish off. And we're forward thinking as an agency, and we want to show our clients how AI tools can help us be more productive and create better results for them. And then finally, some paid advertising on social, Facebook and Instagram, TikTok probably too. It's a young audience. So those are the elements of the campaign. We've assumed we've pitched it to the client, assume the client is happy with it and loves it for the sake of this conversation. Let's quickly run through at a high level some of the risks, and I'm going to be pretty quick about this so that we can leave as much time for questions as possible at the end. All right, so this work's not going to get done in a vacuum or just magically. You're going to need a team. And that team is probably going to include your agency employees. It may also include some people who work in-house at your client's marketing department. But you may need to bring in third parties, freelance contractors for design, for photography, for videography, computer programmers, website developers. Where you need a team, you're going to need some contracts. And I've done a fair amount of talking with agency groups, including one of these Q&A sessions about what we consider the pillar contract documents for agencies to have, and this is no different. So you need to make sure your house is in order with your master services agreement or your professional services agreement in terms, your website development and SLA if you're going to be doing web development work, independent contractor agreements for folks that you're going to bring in to assist in developing the creative. I've included a couple teasers here for provisions that are must-haves in most of these agreements. They need to address the intellectual property ownership of the final work product. They need to address confidentiality. They need to address liability identification. This is particularly becoming important where AI is going to be used to create some of the deliverables, because everybody is very concerned about who, at the end of the day, is responsible for infringement or product or content accuracy, product claims in the final deliverables when you use AI to create them. All right. Then, speaking of AI, we're going to use some AI because we're experimenting with it. We think that it might help buttress our results or boost us a little bit, and it may or make us more efficient, or be able to give our clients more bang for their dollar. And so we might use generative AI to do research. We might use it to, again, develop first drafts, or even to develop strategy ideas and proposals. Um, Before we think about integrating generative AI into creating the campaign, three top level recommendations for you all as you walk down this path. And I'm going to talk a little bit later about some help that we can provide you in that area. But for the purposes of this discussion, three things I want you to be thinking about: crucial conversations, and those are the conversations that your agency has with the client, so that you have a common understanding about how AI is going to be used, what the use cases for it are, what sort of platforms or tools you intend to use. You need to be asking the client if they have a corporate policy regarding AI use. You need to be asking them about any confidential information they're giving you that they don't want you to feed into any AI generative tool. So, crucial conversations, written internal policies for your team, and external policies that are client facing or perhaps vendor facing, that discuss how and when you use AI, and what your guardrails are around it in terms of, human review and approval of the final work product. And then you're going to need appropriate contract language finally in all of your agreements with your clients, with your third party creators, with strategic vendors, anybody who is contributing to the final work product. So, conversations, policies, contract language, some crucial things to get out of the way before you start creating. All right, now let's get into the campaign itself, because it's very fun to think. Oh, it's fun for me. May not be fun for some of you, especially if you've run into hurdles in the past. But let's talk about some potential challenges here. First of all, what about those taglines, right? We are looking at a way to sort of brand our product so that it speaks to the particular segment of the audience that the client wants us to reach. So these are two examples: everyday risks, ensure your better future. What about trademark searching? Who's thought about doing a trademark search for these taglines to make sure that they are not bumping into any other trademark usage out there in the marketplace for competing products or services? Start early on this to avoid having to go too far down a path and then disappoint your client by having to tell them that you've got to start from scratch again because something's not available. Get the client's buy-in to making sure that due diligence is done. And it's okay if at the end of the day, the decision between you and the client is that the client will take that burden on. Just make sure that's one of you is doing early preliminary knockout searching at a minimum, and then full searching before you actually release the tagline out into the world. Remember that finding an available tagline or domain name, or excuse me, tagline or brand name is more than just finding a domain name that happens to be available. It's great if you do find the right domain. That's not the end of the story in terms of potential trademark conflict or infringement. So be aware that there is a difference between using a phrase or a sentence as part of a domain versus using it as a trademark. It's two separate legal analyses. The key thing you want to look for is, would this be likely to confuse a customer? If they saw our tagline and they saw this other tagline, might they have a hard time telling who is who? That's sort of the hallmark, the gateway to potential trademark infringement problems. So that's a good question to keep in the back of your mind, and to have your branding folks keep in the back of their mind as they develop tagline or brand suggestions. And then the other thing I wanted to point out with respect to this is, once you've made your decision and the client has bought into the decision about what your brand extensions or your taglines might be, start your trademark registration process as early as possible. It is taking between 9 to 12 months to get just an initial reaction from the US Patent and Trademark Office to an application. So the earlier you can start, the better. All right, so that is branding and trademarks. What about that microsite we talked about? You're going to engage a website development firm to handle the design and layout. And they're going to be a strategic partner with you. Remember, we talked about contracts with strategic partners. So you need a contract between your agency and them. Um, what about videographers, photographers, and computer programmers? What about the individuals who will be subjects in your person on the street videos when you ask them for their candid reactions to insurance products at their age and given their stage of life? Um, the case studies, the interviews that will be written up, the copy that will go on the microsite, the downloadable information pieces that the consumer will be able to access. All this stuff will be launched off of your microsite, which is kind of your nerve center for the campaign. Um, and what about all the legal issues associated with that? So again, you need written agreements with everybody in the project, your independent contractors, your strategic partners, other vendors. Um, if you're using stock photography, this sounds like it goes without saying, and it does, but you would be surprised at how many times in the haste of getting a website launched or a campaign launched, the actual finalization of the purchase of a stock license actually ends up being a problem. You just forget. You use the thumbnail and you go live and nobody goes back and retraces and ends up securing the licenses. So proper stock licenses for video assets, fonts, photography. If you've talked to humans and their likenesses are going to be appearing in any of your campaign materials, even if they're not famous people, releases, location releases sometimes are appropriate as well. Definitely people releases. If there's a call to action, and I hope there is, otherwise, what's the point, right? Your call to action requests and pages and forms, make sure they've got the proper opt-in and subscribe language. You don't want to go through all this trouble to set yourself up to do direct response campaign by email or however you plan to do it, text, email, whatever, and not have the proper opt-in after you've done all this work. So make sure your call to action pages are properly set up for subscribers. And then you need terms of use and privacy policy. It might be appropriate to refer over to the corporation's main terms of use and privacy policy on the website, or you may need a special one for this particular campaign. But double check before you launch. All right, consumer surveys and the sweepstakes that you might need to get somebody actually interested in responding to your computer survey, your consumer survey. We're going to ask responders about their knowledge level regarding risk, insurance, what's their attitude about insurance. And we're going to choose some respondents at random for pricing. And we're going to drive some folks to the survey with social ads. And possibly we're going to have some influencers promote the survey on their own channels as well. All right, so take a step back for a second. Do we have the official rules ready for the contest or the sweepstakes? Do you have in advance, are you ready with your eligibility and release affidavit so that when you pick a winner, you're ready to quickly get their sign off before you issue the prize? This may not be as big of an issue if your pricing is very modest, right, or tiny. There's a difference between doing a $10 Starbucks gift card and giving away an all expense paid trip somewhere fun. So depending on what your pricing is going to be, make sure your official rules are in place, make sure your winner affidavits are ready. If you are expecting any of the respondents to provide any personal information, then you need appropriate disclaimers about what you're going to do with that information. Use it for promotional purposes, not share it with third parties. Whatever you plan to do, you must disclose. And also, if you're going to be running your promotions in any of what we like to affectionately call the trouble states, as far as contests and sweepstakes are concerned, then you want to make sure you get your bonding if it's necessary, or your advanced registration. And that tends to be issues only in the states of Florida, New York, and occasionally Rhode Island. Those are the three states we mostly concern ourselves with. It's not to say there aren't other states out there that have particular rules we want to be sensitive to. Those are just the ones that happen to come up most frequently. Okay, influencers. We're going to talk with them and get them on board to help build a following around um, the issue of risk management, insurance, why you should be thinking about the future if you're a young person. So influencers are well positioned to do this, of course. So maybe we're going to have them create their own content around how they view everyday risks in their lives, what their hopes and dreams are for the future, how they express those hopes and dreams creatively, and associate those expressions and that communication and content with your brand campaign. So we'll have some hashtags, some appropriate hashtags along with it so we can track some of the traffic that way. And we're going to be paying these influencers. Some of them might get money, some of them might get free products or advisory services. Some of them might be invited to special events that are exclusive and not open to the public. The point is, whether it's money or some other sort of consideration, they're going to be compensated. So we need written influencer agreements with these folks. Content originality and needs to be promised. FTC rules need to be followed. We need behavior and morals clauses in the agreements. And then we need a clear expression of our right to repurpose the content, because one thing we may want to do is take content that an influencer creates and use it on our microsite or even on our main corporate website for the business. Has somebody vetted the influencer to make sure that they are familiar with the FTC compliance rules and how to be compliant when they create and launch their content? And is there a plan in place amongst your team or amongst a team that is in-house with the brand to monitor the influencer campaign once it goes live, especially if it's going to be on the influencer's own channels? You want to make sure that somebody is ready to do that so that any missteps can be quickly corrected. All right, so a lot of the integrated elements of the campaign are designed to get the almighty email address. Still powerful in marketing, still one of the number one tactics for getting attention for sales of products and services. And so we want those email addresses of these potential consumers who are in the demographic we're targeting. So how are we going to do that? Some regular e-publications, some direct response emails, probably some traffic promoting the survey and the pricing that might go along with the survey. What is your mechanism as an agency, or what's the client's mechanism for tracking the opt-ins? It's great to take the time to get everybody's proper opt-in, but if you don't have a way to quickly find it and track it, you're gonna have a hard time if somebody contacts you and says, I don't want to be on your list anymore, or I want to know what information you have collected about me, et cetera, et cetera. So you got to be able to track it and be able to know how you got the data and from what source. You have to make it easy for consumers to opt out of your promotions. That means not being sneaky about hiding it in footers. That means obviously you don't want to lead with it, but you want to make it easy for a consumer to be able to choose not to receive the communications anymore. And another reminder again about stock imagery and licensing of images, especially if they are influencer provided images, because they're not all taking their own pictures, right? Some of them are using image banks themselves, and so you need an understanding about that. All right, so paid ads on social. Facebook still a lot of traffic, despite the somewhat declining popularity of the channel. Instagram still huge for paid ads. TikTok. So you plan to run campaigns on maybe you'll create a special channel for this particular campaign. Maybe you'll cross-reference the main brand's social channels and run the campaign there. And maybe your some of your influencers might want to run ads as well. So the ads might focus on getting survey responses. They might direct traffic to your microsite. They might direct traffic to a landing page so that somebody can request an appointment or a piece of content or to be matched with an advisor. All right, some things to think about as you are launching your paid campaign on social. Are Have you complied with the platform's requirements for advertising in terms of disclosure, privacy compliance, etc.? Because in addition to complying with the FTC rules and the law in general, each platform has its own particular set of rules and restrictions around running a paid advertising campaign. If you're building lookalike audiences to target these ads, are you following the data privacy rules as you do so? Um, did you get the proper opt-in to be able to use that data in the way that you plan to do it? Do the ads feature any individuals or consumers off the street? And if so, did you get their permission to do that? And do you have adequate privacy policy and user terms displayed wherever you're directing traffic, whether it's the official rules of a contest or the terms and conditions and privacy policy of a microsite or similar? All right, that was a very, very fast tour through some of the things to be thinking about as you launch a multifaceted campaign. So that's great, Sharon. What do we do now with all of this? I'm gonna give you sort of a clue to some resources here. First of all, you're going to have access to this replay, including all of the awesome and insightful questions that your colleagues, I hope, are about to ask so that we can talk about them. So share the replay with team members, maybe who were not able to make it here today. You're going to also get a link to a free resource center from us. Particularly, there's some awesome stuff there related to AI, not only content regarding artificial intelligence and how it's integrated into your work, but also our AI toolkit, which is designed for agencies to help them comply and be ready in their contracts and their policies, et cetera, in their conversations with clients and other third parties. You can always go to our blog. There's some very helpful resources there about particular elements of a campaign, copyright specific, trademark specific, data privacy specific. A lot of helpful starting points there. Our private training sessions are always an option for you, where we take a deep dive into a particular area that is important to your team because it's a discipline that they frequently engage in. Our AI toolkit, as I just mentioned, and then our agency contract packages, which are sort of a quick start way to be ready for managing some of the risk that you might see along the way as you get ready to create and execute these awesome campaigns. So at the QR code, we'll take you to the resource center, which is a starting point. And I will tell you, we're going to be adding resources between now and when we send you out the replay recording of today's conversation. So be on the watch for that as well. And with that, I am going to take a pause, and I hope all of you came with some really, really hard questions because I'm ready to answer them.
Okay, so Sharon, we do have a few questions in chat, so
Okay.
I'm just gonna work through these, and as you guys listen to the answers and think of more questions, keep putting them in chat, and we'll answer for as long as we have time. So first question, Sharon, comes from Michelle. She said, how do companies and individuals get away with using licensed music and images in memes, TikTok posts, parody videos, etc.?
Well, I assume you mean get away with music that you presume is either well known or it's owned by another party. Um, Sometimes they're infringing. Sometimes they are using alternate versions of the tracks, which are in a library that they have a license to. And sometimes they actually go out and get the license. And so it's hard to know whether or not they're using it legitimately as a consumer or as an agency. For example, if what you're saying is that another brand or another agency uses these things without having license. It's hard to know unless you need to do a little bit of digging, and most of us won't really pursue that unless it's our ownership rights that we're concerned about preserving. But there are some private negotiations that go on behind the scenes between the publishing rights owner and the advertiser is one answer. And sometimes um, bits and pieces of songs can end up in um, the official platform libraries and be usable that way. Good question.
Awesome. Thank you.
Mhm.
Next question. Do you need a release from someone only if their image is shown, or also if you're just using a written testimonial?
Both cases, right? This is commercial use. So if you're using anybody's face or likeness, even if they're not a famous person, because it's commercial use, because you're not a journalist or using this for educational purposes, you should get a release for somebody's photographic likeness, video likeness, as well as a testimonial or otherwise.
Okay, awesome. And then regarding the conversations with your client about AI, someone asked, when is the appropriate time to have these conversations? Is it just before you run a campaign or the start of your engagement with a new client?
I think if you have the opportunity at the start of the engagement, that is the best time because it agencies are really in a great spot to position themselves as leaders when it comes to how to use AI in marketing. And so this is gives you a great strategic advantage to be able to have the conversation then, but it also gives you sort of the warning signs regarding any corporate policies you need to be aware of as you're recommending strategies. Um, it gives you the opportunity to sort of have a checkpoint about asking regarding their confidentiality policies, and whether there's some data they're giving you they don't want fed into any generative AI machine or tool. And if you haven't done it at the beginning of the relationship, I would do it at the beginning of every project that you might use generative AI to create some of the final deliverables. And it's I think that having the conversation, one of the reasons we put in the AI toolkit a discussion guide for agencies to use having the conversation with clients is because this should be a two-way street, right? It should be the opportunity you have to educate them about things they're probably not thinking about and helping your marketing department counterparts sort of save their tails with their superiors around AI because there's lots of things that they haven't thought about in terms of risk. Um, but it is also a way to make sure you're not missing anything, right? That you didn't forget to ask a question until you already did the work, created a potential deliverable, and then it's, uh-oh, we didn't tell them that we were using this tool to create it. We didn't tell them we wanted to feed this information into the tool to see what kind of results we would get.
Awesome. Thank you.
Mhm.
Okay, next question is from Pete. He said, what is the difference between R, mark for logo, and TM for tagline? Can tagline be part of the logo or better to be separate? Thanks.
Okay, that's a couple questions, and I love it because I got my start working with marketers and then agencies as a trademark lawyer. So I love trade. I love to talk trademarks. I could nerd out about it all day long. So a couple of things. First of all, TM versus Circle R. Circle R designates a federally registered trademark. So if you have not achieved that registration with the US Patent and Trademark Office, no Circle R yet. TM doesn't actually have any legal significance. However, it is conventional to use it to indicate a proprietary mark. So it's a brand, it's a sub brand, it's a tagline that you claim common law ownership rights in. And it's important to use it because it diminishes anybody else's claim that they didn't know that you considered it proprietary. So it's good strategy to always use it and then swap it out with your Circle R once you achieve your registration. And again, because it takes so long to get a registration, it's at least something that you can put adjacent to the mark to show that you are considering it proprietary. So that's TM versus Circle R. Taglines versus word marks versus logos. Sometimes as you're building out a trademark portfolio for the client, and building your brand guidelines, you will suggest they use it in multiple iterations. Sometimes the main brand with the tagline, sometimes a tagline alone, sometimes brand tagline plus logo, et cetera, et cetera. Um, the best belt and suspender approach is to register them individually as well as together. Um, Sometimes there are not enough resources to invest in that protection all at one time. And so then you've got to start with what's the most crucial part of the brand identifier for us. For most brands, it's the literal element, it's the words. Um, it's Xerox versus the logo that goes with Xerox or the color blue. But that's not true of everybody. And in some cases, if you are using a word brand that isn't particularly unique, except for has it's paired with the logo or the tagline, then sometimes your best strategy is to register them all as one unified mark because you got a better chance of getting protection that way. So this is definitely a strategic conversation on a case by case basis to have with your trademark counsel, but they can all serve separately, potentially as registerable and ownable trademarks, and they can serve together as a unitary mark as well. What matters is how you actually use them and apply them on the collateral, on the website, on the social platforms. So the way you register them needs to match up with the way you use them.
Okay.
Thank you for the trademark question. I love an opportunity to talk trademarks.
And I do have another question, Sharon, kind of looping off of this. So I'm going to go ahead and ask this, and then I'll get to the some of the other questions on different topics. So Shauna asked, if you have a word mark registered, can you put the R next to the logo?
If the logo is not part of the federal trademark registration, the circle R should just go by the word.
Okay.
And if you're going to be using them together as a unitary mark frequently, register the second iteration of word plus logo.
Shauna said the logo is the word. Does that still apply?
The logo is the word. Oh, so maybe a stylized type font, for example. Maybe it's the
Yes.
brand, and yeah. I'd still register it both ways, Shauna. Word only and stylized word, just to be safe. If you have to make a choice, if you have a budget choice to make, then register the word only.
Awesome. Thank you.
Yeah.
Okay, next question is what happens, and this is a little bit of a complex question. So Sharon, if you need me to repeat anything, let me know.
Okay.
What happens if a client is using a campaign theme for a specific campaign only, and it happens to be close to a trademarked tagline for a company not in the same part of the company? Can a campaign theme or slogan be used as long as it is not a long-term use as a tagline?
I'm sorry, Hannah. Say that one more time.
Okay. Okay. So a campaign theme for a specific company is what they're using, and it happens to be close to a trademark tagline for a company. I guess it's maybe a company with different branches. Can a campaign theme or slogan be used as long as it is not a long-term use as a tagline?
If what you mean, and I think this is what you mean, is adopting somebody else's tagline or slogan temporarily, um, I wouldn't recommend that strategy because infringement is infringement. You may have caused less damage, but I'd push all that to the side if the brands don't compete. If the tagline you're borrowing or the phrase you're borrowing is from a company that I think what you're saying is though they have multi divisions and one of them might do the thing that your client does. So in that case, I would not borrow it. I do think it's potentially infringing. Your
And
risk
just
is
to
lower
clarify,
if you use, yeah, I mean, it's a risk analysis of how long are we going to use it, how many people are going to be touched by it. Are we likely to cause confusion? Those are the elements that you want to look at.
and so this person mentioned that they're not in the same part of the country. So I'm not sure if that matters or changes your opinion, but
There would have been a time when that would have made a bigger difference than it makes now. And there still can be regional arguments made. But these days, with commerce being in interstate in just about every single case and online, that is a less impressive defense than it used to be.
Okay, and if I got that wrong or if there's more clarification needed, just
Yeah,
send me
please do.
a message into chat and I will try to refine that. But for now, I'm going to move on just because I know we're kind of running out of time here. So next question is from Luciana. She said, I used to work in a big company that received a couple of demands for not having the website accessible. Is this mandatory for every website, landing page, and microsite?
I think you have to, is it mandatory? It's not mandatory technically. Um, is it the right thing to do? Yes, it's the right thing to do. If you don't have the resources to do it on all of your microsites, then I think you have to triage it based upon the length of the campaign, the amount of potential reach you think it might have, and make your choices that way. Um, ADA accessibility compliance is a tricky thing for a couple of reasons. First of all, there are no actual ADA federal regulations regarding website accessibility. There are only guidelines, and there are commonly accepted guidelines, but those are not implementable necessarily in every single website. That's part of the problem. The other part of the problem is we sort of got this cottage industry of um, lawyers who, are looking to make claims based on lack of having these features. So I'd say if you're going to be designing a lot of these, or if you design sites in general regularly, then your default should be to build into your budget for the client doing whatever needs to be done to make them accessible pursuant to the, I think it's the WEGU requirements under the ADA accessibility rules. Beyond that, I guess the best I could say it's a risk analysis based on, again, size of the reach and duration of the campaign.
Okay, awesome. Thank you. Okay, next question comes from Tucker. He said, how do you advise agencies to consult clients about the best practices for navigating GDPR and data privacy, especially when it comes to website opt-ins and ad campaigns? At a high level, what are the main takeaways you advise agencies to always ensure with their clients?
A couple of things. First of all, you have to be diplomatic about the way you say this, but the bottom line amongst us agency folks is you can never be 100% confident of the hygiene of the data, the personal data that your client ports over to you because it came from multiple sources. It came from trade shows, it came from direct response campaigns, it came from a million places. And so everybody has to assume, if we're being grown-ups, your agency and your counterpart at the client has to assume that there's some potential compliance risk there. I would point that out to say, look, your list came from likely a lot of different sources. It's very difficult to attribute any personal data with the actual source, no matter how careful we try to be. And so that's just a reality of using data to either run social campaigns, do direct response campaigns. That's the first thing. The second thing is, reminding the client that it doesn't matter where they do business. It doesn't matter where their offices are. It doesn't matter where your agency is. It matters where the consumer is, where they sit. And it matters, it doesn't matter whether they've actually ever bought anything from you or been a paying customer or not. All that matters is that they're on your list somewhere. You have their data. So my knee-jerk reaction is to always assume there's a California resident sitting somewhere in that data set, because my experience is that in most cases that's the truth, and that there's no way for everybody to be confident that you don't have to comply with the most restrictive state statute right now in the US, which is the California statute. We we are desperately hoping in the industry that we'll get a federal standard for data privacy. but it hasn't happened yet. Um, I'm more hopeful that it might actually happen now that they're dealing with AI as well and the privacy concerns that that raises, but we don't know. So assume there's somebody from California on those lists somewhere. Know that it matters where the consumer lives, not where any of you are, and not where you sell stuff. And have those conversations early on with the client in a way that is helpful to them. The point is not to insult them that their data hygiene is bad, because it's not their fault probably that it is, if it is. Um, but those are sort of my high level takeaways for the conversation.
Okay, thank you.
Mhm.
Okay, next question, and this may be one of the last questions, just because we're getting close on time. So if anybody has anything else, please put it into chat as soon as you can, and we may be able to get to it. But this question is, I was wondering how trademarks, etc., work with DBA companies. Do you need to TM words, logos, etc., for both company names?
If you are using a corporate name as your entity name that is not a part of your customer or client facing brand, my priority would be second there to achieving a trademark registration. What you want to do is own the trademarks to your market facing brands. Um, Many businesses don't invest in trademark protection, unintentionally for their corporate name, because their corporate name might be something like, Toric Co. or ABC Industries doing business as brand. So you can register them both if you're actually going to use them both in commerce to identify your goods and your services. You don't have to register them both. You can have a corporate name completely separate and apart from what you're referring to as the DBA that actually becomes your trademark, your customer and client facing brand.
Um, Okay, and then I think this might be the last question. Glenn asks, social media has put power back in the hands of the customer. What tools, AI, or policies should we consider in responding to negative comments?
That's a great question. I can't opine on an AI tool. I think that the key there, yeah, I'm probably going to disappoint you on technology recommendations, but what I would say is important to do is to talk through your strategy before you launch and go live about how you're going to monitor and react to those campaigns. That's more of a reputation management issue. And reputation management issues are easier to de-escalate if you catch them early. You have more options there, whether it's blocking, removing, whatever it might be. And sometimes it's best to just let the thing exhaust itself. Sometimes you don't have that choice. So the tool suggestion I have for you is, what is your monitoring plan before you go live with the campaign? And that might not be satisfying in terms of, handy widgets or technologies, but whatever you're going to use, you need to be thinking about it in advance of actually going live with the campaign so that you're ready to hit the ground running if something goes sideways.
Okay, I think that is all of the questions I am seeing here. If anyone wants to go open mic, ask any last minute questions, we can do that. But otherwise, I think that's almost it for the day. So
Yeah. I want to thank you all for spending time. It is so much more profitable to think about these potential things in advance and have a strategy in your back pocket for how you will address it. It is so much more profitable to have conversations up front, whether internally or with the client. And it is so much more profitable for you to think about the tools that you're going to need, whether it's those pillar agreements that every agency needs, whether it's model policies, or whether it is a guided conversation with your customers and your clients about, how to adapt the campaign to some of the legal impediments that might face it. The earlier you do these things, the more profitable and frankly, the faster you get to launch because you're not being bogged down by some of these impediments. So thank you for playing all in and asking great questions. And I encourage you to go to the Resource Center. And we're going to be adding resources over the next 48 hours to that, and including some free stuff and including some special things we've got planned for you. I would say you're here, I think, because you recognize the value in education and in training. And so, one of the key things I'm excited to talk about with all of you is the training sessions we're going to be offering so that you have an opportunity to take a deeper dive with your team members on some of these topics. So, more to come about that. Thank you all for being here today. Wishing you a successful end of the year and joy in whatever you celebrate. And thank you for spending your time with us today.
Awesome. Thank you so much, Sharon. Thank you for sharing your smarts as always, answering questions and just being helpful and awesome. So thank you for that. And then for everyone still in the room, just a reminder that we will be sending out the recording of the session. If you guys have any follow-up questions, please feel free to email Kayla, who's also in the room today. I put her email into chat. So if we didn't get a chance to answer your questions, or if you didn't feel comfortable asking, or if you have questions over the next couple of days as you digest this, please reach out to her with your questions. So thank you guys, and I hope y'all have a great rest of your week.
Thanks, everyone.